Sir, you were charged, do you speak English?
Yeah.
Yeah, no,
Yes. John.
better. You're charged with reckless driving, up to 30 days in jail and or a $500 fine. Hey, Conrad, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
I apologize, Your Honor. What's the last name of this?
Turu Biartes, Turru.
Thank you, Your Honor.
Sure.
The officers were surveying a known street takeover group in a large parking lot in Harris County, Texas, when the officers observed the defendant's vehicle spin its rear tires and do approximately 4 to 5 donuts in the pit, coming within 10 to 15 feet of other vehicles. Undercover officers kept their eyes on the vehicle until other officers were able to conduct a traffic stop. The undercover officers also identified the driver as a slim Hispanic male with curly hair. The officers observed the defendant and the driver.
What did you hear that? Judge Boyd just laid out the real-life consequences of a guilty plea. Notice how every right the defendant gives up trial, witnesses, even appeal, disappears the moment they say guilty. It's not just a sentence, it's a permanent mark that changes your future. What do you think?
Seat and the defendant admitting to doing donuts.
Right. Sir, I'm going to find that there's probable cause to go forward with the case. Have you seen if he has a valid license?
I'll run it, Your Honor.
Please. I'm ordering you as a condition of your bond not to partake in this type of behavior again. No racing, reckless driving, donuts, street takeovers. If I find that you do, I'm going to put you in jail. No more PR bonds. Do you understand, sir?
Yes, Your Honor. I apologize, it's loading right now.
Yes, no problem.
It's eligible, Your Honor.
Okay. You mind crafting those orders? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. We'll get you in the jury box. We'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Be careful. Don't drive like this again. Do you understand?
Yes, Your Honor.
Okay, ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 27th, 2024, the officer was dispatched to a disturbance at an apartment in Harris County, Texas. The officer made contact with the complainant and the defendant are cousins. The complainant and the defendant do not live with each other, and the defendant was staying with the complainant for a couple of days. The complainant stated she and the defendant got into an argument about the defendant's lifestyle. The defendant became upset and started to throw the complainant's belongings out of the apartment. The complainant and the defendant continued to argue, and the complainant tried to open the door to retrieve the belongings, and the defendant grabbed the complainant's arm, applying pressure and scratching the complainant's arm, causing a deep cut, bruising, bleeding, and pain. The defendant stated she had been arguing with the complainant earlier in the day, and the defendant stated she got fed up with the complainant criticizing her and asked the complainant to leave. The defendant stated the complainant pushed her and took her phone, and the complainant's small dog caused an injury, and the defendant did not recall injuring the complainant.
Do you know if alcohol played a part in any of this?
There's no allegations, Your Honor.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand? These are your bond conditions. If you violate these conditions, a warrant will be issued. You will go to jail. No more PR bonds for you, man. We will do that. We'll give you time. Yes, we're going to do that now. I'm going to have you sign a reset. Victoria will give you 30 days. But I'm going to have you also take a seat in the jury box. So we'll get your bond conditions. We'll have you sign it, and then you'll be free to go, man. All right? Please. Mr. Ware, you're charged with unlawful carrying of a weapon. You're facing up to a year of jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 28th, 2024, the officer was dispatched to a robbery that just occurred in Harris County, Texas at a restaurant. While en route, the officer observed males walking on the south side of the store where the robbery had occurred, matching the description the reportee provided. The officer called in an attempt to contact the two individuals and located the two males wearing dark hoodies, dark pants, and shirts tied to their heads that looked like makeshift ski masks. The officer made contact and asked if it was okay if they were patted down for weapons, and both individuals ran off. A short pursuit lasted approximately 50 feet, where the co-defendant slipped on a puddle of water, and the defendant ran approximately 5 feet before being grabbed by the officer. The defendant, 19 years old, whilst trying to stand the defendant on his feet to walk him to the patrol vehicle, the officer found on the defendant a loaded Glock 9mm, which fell out of the pant leg of the defendant.
So this is part of an ag rob as well, right?
Amanda Marsh.
Yes, Judge.
What happened on the ag rob?
One moment, Your Honor. So during the ag rob, the complainant stated that while he was walking into the store to grab his food order, the two males stood outside the store watching him, and as he walked out of the restaurant, they blocked his path, and one of them pulled out a gun on him, and the other yelled at him for his wallet and keys.
Where is this?
It was, one moment, there's an address, but not a name of the business. At a Sonny's food store.
Got it. Mr. Ware, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. No more PR bonds. I'm now also giving you a curfew. I don't want you out in the middle of the night. And I'm going to put
This moment right here, this is tense. The defendant's actions escalated fast. Drinking, destruction, and then threats. You can almost feel the fear of the complainant. Judges have to balance protection and fairness. But do you think anger fueled by alcohol should ever excuse violence?
a monitor on your ankles so I know where you are at all times. Do you understand? If I find that you're a danger to my community, I'm going to lock you up and I'm going to make your bond so high. Do you understand, sir? No contact with the co-defendant in this case and no weapons as well. How old are you, sir?
19.
Did you graduate from high school?
Yes, sir.
What are you doing with yourself now?
Not much.
Are you working?
No, sir. I was planning on going to the military. I was talking to a military.
I want to know what you're doing with yourself. If you're working, if you're doing anything, because I want you to get a job. Too much time on your hands, you become self-destructive. You need something to do.
Forklift license. And I'm going to a class for forklifting.
Good. Get it done. You need to get a job, and I want to make sure that you're going to get a job. I'm going to provide you a lawyer today, but I want to see here within the next couple of weeks what you have done to get a job. If you've done nothing, life's not going to go well. Do you understand?
Sir.
In this life, you have to be productive. You have to either get yourself an education or get yourself a trade, a job, because I'm going to tell you now, when you turn 40, if you don't have a career, if you don't have an education, if you don't have anything, this life is not going to be a good one for you, because I'm going to tell you, life sucks without money. You need money. Otherwise, it's going to be just a rotten toilet of an existence. Do you understand?
Yes, sir.
So we're going to make sure here you're going to leave better than you came. So you must either get a job or get into school full time. Do you understand?
Yes, sir.
I'm going to give you a lawyer today, and I'm going to bring you back in 2 weeks, and we'll see what you've done with yourself.
Yes, sir.
All right. Odd McLean.
Yes, sir.
Mr. McLean, you're charged with interference to the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The officer was dispatched to an apartment in Harris County, Texas, in response to a disturbance. Prior to their arrival, the officers were told the defendant was in an altercation with the child's mother, was intoxicated, and had a firearm. Upon arrival, the officers observed the defendant banging on the door to his residence, and the officer told the defendant to show his hands, and the defendant ignored them. The defendant then pulled his handgun from his waist to show the officers that he had it, and then placed it back into his waistband approximately 4 times. The defendant eventually put the handgun down, but told officers they would have to tase him to get him to stop. The officers then attempted to detain the defendant, but the defendant continuously pulled his hands away and kept placing them in his pockets. The defendant was then tased twice, but kept putting his hands back into his pockets. The officers were eventually able to detain the defendant.
Did you say initially you said he was intoxicated, right? Is that what you
Yes,
said?
reports he was intoxicated.
Okay. Mr. McLean, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs and not to be in possession of weapons. Do you understand? What do you do for a living, sir?
Photographer. Do photography.
Okay. What kind of income do you have from photography?
Income coming in, what you want to know, monthly or?
Yeah. and Do you have the ability to hire a lawyer?
Yes.
Okay, we'll give you time. So I'm going to have you meet with Victoria. We'll have you sign a reset. I'll have you get with Fleischer for your bond conditions. After that, you're free to go. All right? Please. Okay. Ready? Yeah, sorry to keep you waiting.
How are you?
Do we have Zuberi, right?
How are you?
Good, man. We have a,
We've been working hard. The case was filed late April. We had a retained lawyer in the beginning. He came to me middle of June. I subbed in late June. I had a couple settings.
where do you want to go? What do you want?
We're asking for about 30 days to flush some stuff out. And I think ultimately, what I'm slightly disappointed with is the way the case was presented by the agency to the DA's office. It's not their fault. We've been put in a time crunch where we got to November and we began to run up against your 180 days. And I think we all kind of realized the agency didn't bring over what they needed to bring over. So
Are you still lacking stuff?
I think we're all in a position where it's less, some of the initial discovery is complete, but because we're all working so hard, there's some subsequent discovery that needs to be done based on some things that we. And so Kelsey's been great. She's working hard, talking to people.
But I mean, what do I need to do? Because we're now at 240 days. We're still missing stuff. It's unacceptable.
I would suggest this is one of those moments where I would say we've all been doing this a long time. If you just trust me, and I say we really just need 30 days to work on some things and then come back, and I think we'll be in a better position then to know with clarity whether we're working this out or not, and we need a trial date.
Well, then I'll give it to you, Lon, but at the next setting, it's clear trial, you know? Like, that's it.
And I appreciate your position is like, hey, look, I've got and have an idea of when and how I want to move things. Every now and then things get messy. This one's gotten a little messy, but
Typically, when we face this type of dilemma, what I do is I order them and I subpoena the people who have,
yeah, this is a little different than that. This is different. And if we were in one, and I think you did that back in November because there were some screenshots or something that maybe weren't complete yet. And then so you asked for a compliance hearing and then some more information was provided, which again, really only happened because the agency in the beginning didn't have a detective assigned to the case to really work it up and dig it over. Like I'm used to small town like detective work. This didn't happen here. And so a lot of it's been thrust in their lap, unfairly probably. And so she's good. We're all good. Got good
Right,
lawyers,
so-
good lawyers working on it. If you give us 30 days,
I'll give you the 30 days, but at the next setting, it's clear trial. I mean, it's it, because by then we'll be, you know, what, 275? So we're close to.
Track 60 that I wasn't on it.
Yeah, I mean, and that's why I'm giving you the benefit of the doubt.
3 for 1.
Okay, all right, we got it.
Thank you, sir.
Okay, sure. You were charged with driving while intoxicated, first offense.
第一个指控是您被指控醉驾，
It's elevated to a Class A misdemeanor because of the high blow.
因为你吹气的时候，它的这个指数比较高，所以它的这个罪行有就指控加重，成为了第一级的轻罪。
You were facing up to a year in jail and or a $4,000 fine.
您将会面临高达1年的服刑，或者可以或者是$4000的罚金。
We are going to do probable cause. You have the right to remain silent.
你有权利保持沉默，我们将会做一个可能性的证据。
Anything you say can or will be used against you.
您所说的话可以，也可能将会 对你不利。
Officers were dispatched to a major crash in Harris County, Texas.
在德州 Harris 县，警官被派遣到一个汽车事故现场。
Complainant told officers that he was sitting at a red light and was rear-ended by defendant.
指控者告诉警官，他当时在红绿灯那边等红灯，最后被一辆后面的车追尾。
Upon arrival, officers found the defendant standing next to his car.
在到达现场的时候，警官发现被告人在他的车旁边站着。
Defendant repeated to them that the accident was his fault.
被告人一直不断的告诉警官，这次的事故是他的错。
Officers observed bloodshot eyes, slurred speech, strong odor of alcoholic beverage, and poor balance.
警官当时看到他的眼睛通红，说话的时候不清楚，同时他平衡非常有限，有一些酒精的影响。
The defendant admitted to drinking 2 beers.
被告人承认他喝了2瓶啤酒。
Standard field sobriety tests were conducted.
标准的现场酒精测试执行。
6 out of 6 HGN.
The interpreter requests a repetition.
6 out of 6 HGN.
HGN 的指数是6。
8 out of 8 walk and turn.
走路和转弯的平衡度是8。
3 out of 4 one leg stand.
一只脚站立的指数是4个里面有3个。
DIC red and breath consented.
DIC 是红色，然后它的这个呼吸也是经过同意的。
The results were 0.174, 0.174.
呼吸的结果是0.174， 0.174。
He has no prior DWIs and no license. I'm sorry, driver's license is eligible.
之前没有任何醉驾的前科，所以他的驾照是有资格的。
Mr. Luo, I'm going to find that enough probable cause exists to go forward with your case.
罗先生，我觉得我们现在有足够的证据，可以认为我们可以认定你是有罪的。
I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs.
Your Honor, the interpreter needs to clarify one thing. Go forward means that you can find them guilty or not.
I'm finding there's enough probable cause to go forward.
Oh, go forward. Okay.
Correct.
OK， 那抱歉，刚才说的是我们有足够的证据可以继续审理这个案件，而不是说你认定有没有罪，是继续审理这个案件。
I am putting conditions on his bond, and if he violates them, his bond will be revoked.
那我们现在给你一个保释金，那我们将会有相关的保释金的条件。如果要是您违反了保释金的条件，那你将会有后果。
I am ordering you not to consume alcohol or illegal drugs.
我命令您不要喝酒精或者是吸毒。
You will be randomly tested.
您会在不定时的情况下被检测。
If you fail to go test or if you consume alcohol, your bond will be revoked.
如果您要是在检测的时候没有过关，或者是您喝了酒，那您这次的保释金将会被撤销，将会被没收。 So the interpreter requests a clarification because there is some I couldn't hear some of the words. So if it's failed to the test and the consumption of alcohol, his bond is ineligible?
So what happens is if he tests positive for alcohol or illegal drugs, I will revoke this bond and put him in jail.
Okay, that's what interpreter was. OK， 所以如果要是您的酒精测试是阳性的，或者是您喝了酒的话，那我们就会把您的您直接就进监狱，然后呢，您同时也没有保释金了。
We are going to reset your case to give you time to hire a lawyer.
我将会给你时间去寻找律师，同时我们也将会让您的出庭日期重新安排。
Do you have any questions?
有什么问题吗？
因为我有三高，我从来不喝酒的，只是因为那天过节日，过圣诞节我喝了以后，都是已经5、6个小时以后才开的车，但是我不知道为什么这个车是这么高。我从来因为我有三高，每天需要吃药，我根本就不喝酒的人。
Okay, so I have high blood pressure, diabetes, and high cholesterol, so I hardly ever drink. And that was during the Christmas holiday season. I drank
Okay,
very
hold on,
little.
ma'am. I don't talk about the case.
No, that's the interpreter's job is to interpret for it. So it's not the
Right.
interpreter interpreting, it was Mr. Law was talking.
I don't want you to say it because he has the right to remain silent.
Okay,
Anything he says, they can use it against him. And I don't
Okay.
want him to say something that hurts the case. I'm trying to
Okay.
prevent that from happening.
Your
If
Honor,
you could tell
if you can address to the defendant instead of to the interpreter, I think that
Okay.
would be properly. 'Cause-
You have the right to remain silent.
Okay. 你有权利保持沉默。
I do not want to talk about the case now.
我现在不想谈这个案件。
Anything you say, they can use it against you to prove guilt.
如果你说的任何事情都可以把作为您的这个证据。
The
让
only
你有
thing
罪。
you need now is you need a lawyer.
你现在需要的就是需要个律师。
We will give you time to go look for a lawyer.
我给你时间去找律师的。
Understand you're not to consume alcohol or illegal drugs.
你现在要理解的是，你现在不能够喝酒，也不能够吸毒。
Do not violate the law. Do not pick up any new criminal cases.
不要犯法，也不要去做任何违法的事情。
If you do, then I'm going to put you in jail. No more PR bonds.
要是你出现这样的问题的话，那你直接就进监狱，
No
没有什么任何可以保释的机会了。
For now, I will have you sign a reset with Victoria.
那现在呢，你可以跟 Victoria 那边签一个重新安排出庭时间的文件。
You will then sign with your bond conditions, understanding the bond. You will sign a paper indicating you understand your bond conditions.
你将会签个文件，上面会表示你已经了解了保释金的条件，
And then you're free to go.
然后你就可以走人了，
Please.
可以吧？
Okay. Ball's in your court.
Your Honor, Mr. Biagas, when he climbed to the mailbox pole, he didn't stop. He got out of the car. There's no one to talk to. And so from there, he went to his residence, Your Honor. But, it's not a case where he didn't identify himself or anything. And then we don't know what the restitution amount's going to be for the mailbox.
My concern was that according to the statute, right, it says that you're supposed to, I don't even know.
Take reasonable steps to locate and notify the owner or person in charge of the property of the collision.
What time, was this the middle of the night?
$1:50 in the morning.
I don't think it'd be reasonable to knock on anyone's door. I don't think anyone would open.
I mean, reasonable steps, you know where the person lives, you hit their mailbox. It would be pretty easy to walk up and knock on the door.
Is that reasonable? I mean, if you go up to someone's door at 2 a.m. and you start knocking on the door, are you going to scare the,
Probably, Judge, but I would want to
No.
know if it were my mailbox and somebody ran their car into it.
Would you open the door and go out?
I would look through the peephole and I'd see,
I
and then I would
guess
see
there
a
are
crashed
other,
car.
there are other measures I guess you could take theoretically,
Do something,
right?
Right.
I guess leave.
Right.
Maybe leave a note on the door.
Okay, all right. Mr. Biagas, come up. I mean, reasonable measures, right? And I guess that would. Have you run his license, see if he has a valid Texas driver license?
It's
Mr.
an out-of-state Florida license that appears valid in our system.
Okay, Mr. Biagas, I'm going to find that there's probable cause to go forward with your case. I'm ordering you not to drive any vehicle unless you have car insurance in your name. Do you understand? If I find that you're driving without a license and or liability insurance in your name, it's not going to go well for you. Do you understand? Okay. You've got a lawyer. Listen to your lawyer. He'll take care of you. I will waive your appearance so you don't have to waste your time coming to court, but you have to stay in touch with Mr. Famine. He'll tell you when you have to come back to court. If he tells me he can't get a hold of you or you pick up a new case, I'm going to revoke your bond, put you in jail. No more PR bonds. You understand? Okay, guys. Any conditions you think?
I'm okay with your conditions, Judge, just no driving without
Yeah,
insurance.
just
Law
be
violation.
careful out there, okay?
He does have insurance. Can you rip the CW and
Yes.
then we can settle it?
You did have insurance,
Yes.
hopefully.
Yes, sir.
Okay, wonderful. Great. Okay, all right, man. Take care. Have fun. Can you file that? Do you mind those conditions? All right. Michael, he still needs to sign the conditions and then he can go.
Yes, ma'am.
Okay, so just, sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 28th, 2024, the officer came to a stop behind the defendant's vehicle and the light turned green and the defendant's motor vehicle proceeded and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed slurred speech, bloodshot eyes, unsteadiness on feet, and an odor of an alcoholic beverage. The defendant admitted to consuming one alcoholic beverage and standard sobriety tests were administered. HGN 6 out of 6. The walk and turn on one leg stand could not be performed due to the defendant complaining of leg pain. The defendant was read the DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license?
It's eligible, Your Honor.
All right. How many prior DWIs does he have?
He has one prior, Your Honor.
One? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Stewart and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel and he'll tell you when you have to come back. You understand?
So I need to wait for him now.
We're gonna have you wait for him now, but after today, I'm gonna waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence, or while he gets evidence to work the case up.
Wait for him.
Right, I'm gonna have you sign a reset. I'll have you meet with Fleischer for bond conditions and we'll just have you waiting back for Mr. Stewart to show, okay? Please. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer was dispatched to a disturbance at a
And that's Judge Boyd giving one of his signature reality checks. Don't become a statistic. You can tell he's not just talking law, he's trying to save lives. These lectures are part warning, part wake-up call. If more judges spoke this bluntly, do you think DWI rates would drop?
residence in Harris County, Texas, and the complainant, the mother of the defendant, told officers that the night before, her and the defendant had gotten into an argument. The defendant returned the next day to get his belongings, and the defendant walked up to the complainant with a fighting stance, and the complainant told officers that the defendant grabbed her wrist, causing pain and scratches, and attempting to pull her. The defendant stated, "No, bitch, you're coming downstairs with me." The complainant pulled away and the defendant then slapped her in the face, causing pain. The witness, the defendant's sister, also saw the assault.
Mr. Brunson, I'm going to find that there's probable cause to go forward with your case. No, now's not the time. You will have the opportunity. Now's not the time. I'm just trying to find if there's enough probable cause to go forward. If so, what kind of conditions to put on your case, if any? Have you reached out to the complaining witness? Do we know what she wants?
So we made an attempt and she couldn't speak to us at the time we called, so we'd have to reach out.
Okay, Mr. Brunson, because I always like to follow the wish, stop. I'm letting you know what the expectation is in this court. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Whatever you say, they're going to sit there and type it and use it against you. I like to follow the wishes of the complaining witness. When I don't know what they want, I'm going to order you not to have any contact with them. I'm also ordering you not to be in possession of any weapons as well. There is a protective order that has been issued in this case, and if I were you, I would get to know it, because if you violate the protective order, the state can and will file additional cases against you, including a violation of protective order, and that is the capital murder of misdemeanors. Do you understand? So get to know it. We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria and sign a reset. We will have you take a seat in the jury box while we get your bond conditions ready, while we sign it, and after that, you'll be free to go. All right, please.